Hi, this is group number 34 for the presentation of business and corporate law. My name is Pema Lama and my student ID is YSC2033.
My name is Monos Thapa. My student ID is ABN2178.
I'm Susan Varel. My student ID is NPS2998.
Myself, Binay Rajbahak. My student ID is YSE2047.
Hi, I'm Bikram Yonjan. My student ID is EAB2694.
This presentation is between GORE and ASIC in 2017, where two Gold Coast-based companies, namely Active Super controlled by Jason Burrow and the Royal Capitals controlled by the Justin Gibson, prepared a scheme and raised $1 million from the Australian investor. They raised around $3,100,000 from total 187 super funds, from which only $455,000 were utilized and rest were made as a loan arrangement to the Gold Coast-based property development company, MOGS. Directors were Marina and Stonehouse. Let me continue with the background of the case. On 29th May 2015, Federal Court made judgment against GORE, stating ban for the company, including Grace GORE, permanent ban for him, Jailfree George, permanent ban, Marina GORE, 7-year ban, Jason Burrow, 10 years ban and disqualified for the managing of company, whereas for the Justin Gibson, 7.5 years ban and disqualified for managing a company. For the rest of the presentation, my friend Manoj is going to help for that.
Now I am continuing our group assignment presentation. My group is background of the case. 19th June 2015, GORE filed an appeal against finding the predicting to her discrimination freed appeal to her liabilities placed on her cost. On 8th July, ASIC filed a cross appeal to make the 7.5-year ban into the permanent ban. Later, both cases were dismissed by the court. Stonehouse were held not knowing connecting with the violation of law in setting up the fund 45% of its legal expenses to get from ASIC, where Martin and others were ordered to pay 95% of the expenses which ASIC had incurred. Now, my friend is going to continue.
I'm going to explain the part where we're going to talk about the breach of the law. Primary allegation against GORE was about her breaching Section 727 of the Corporation Act 2001. This section states that if the company wants to raise funds in Australia, they have to first issue a disclosure document. Disclosure document could be short form of prospectus or proposed statement, each with different set of requirement and a different threshold, provided under Section 750 of the Corporation Act 2001. According to the Chapter 6D of Corporation Act 2001, what can be plainly termed as provision relating to fundraising through which the manner of raising capital as that in assurance of a formal disclosure document is regulated. While they raised the capital, they were not entitled to any of the exemption listed out in Chapter 6D or the Corporation Act 2001. Thank you. The next part is going to be presented by my friend.
The critical analysis of this case shows that the fact given Australian investors were influenced to set up self-managed super fund for investing. Later, ASIC initiated proceeding against GORE and other for non-compliance with the disclosure requirement of the Corporate Act 2001 in connection with offering securities and misleading investors and uses of funds invested by them. GORE was held by court as having been knowingly concerned with contraventions. Court found Marina participating in dealing and made concern in contravention that occurred according to Corporation Act 2001 for offering securities without having prospectus or any document registered with the ASIC. Court made the judgment based that Marina was aware of necessity of disclosure under Part 6D2 of the Corporation Act 2001. Marina's possessed sufficient knowledge of what the scheme was and what steps were taken to which her intentional participation was considered under the Corporation Act 2001. Further details will be given by my friend. Thank you.
Talking about the relevance of decisions were given under Australian corporation law, which states that the companies operating in Australia provides professional service to corporates such as accountants or financial advisors could be held as a being misconduct on part of someone else, even if these professionals were unaware of particular provisions of the Corporation Act 2001 being violated through someone else's misconduct. Therefore, they should be more careful not to get involved in disreputable dealing, which could make them accessory even if they may be not aware of the law. This decision even made by the honest companies to think of ways in which a transaction can be done to avoid any contraventions. Thus, decision has helped to figure out that breach of Corporation Act 2001 could potentially have both civil and criminal consequences. ASIC found it difficult to pursue any actions due to which certain company with malicious intent would get opportunity to be free, knowing ASIC would not be able to pursue them. This decision is encouraging fraudulent companies to operate in a much more brazen manner. Thank you.